Merci beaucoup pour cette analyse de la situation française qui part du monisme pour arriver, on ne sait pas où, à ce moment, et surtout pour ces conclusions et ces observations finales sur les conséquences d'attitudes théoriques ou d'attitudes démonstratives du point de vue du résultat concret qu'on peut atteindre sur ce qui est le futur contenu des règles internationales et l'application des règles internationales. C'est là encore ce que je me suis permise de dire tout au début, à savoir l'effet des déclarations des juges à travers leurs décisions sur le développement du droit international et en tant que manifestation de la volonté, de la perception de l'État en tant qu'adhésion à la règle internationale plutôt qu'objection et résistance à la formation ou au contenu d'une règle internationale. Merci encore une fois. And now I give the floor to Professor Paulus, who is professor at Göttingen and is a Richter im Bundesverfassungsgericht. He'll introduce us to the German legal order and in particular to relevance and primacy of EU law in that legal order, legal theories and constitutional jurisprudence. You have the floor, Professor Paulus.
Thank you very much indeed, Madam President, and thank you very much for the invitation to speak here and for your enormous hospitality, which even extends to my use of the English language instead of the beautiful Italian language. It's the third time I'm here for this term, for this semester, but I haven't managed to learn Italian yet. I will try, I promise. And I'm particularly honored to speak in presence of Professor Condorelli, who was in fact my first professor of international law in Geneva some 30 years ago. And that also shows that, after all, my international law I learned from an Italian. I think that is remarkable and may explain why you invited me after all, in spite of my disregard of the Italian language. And indeed, I'm here in a double function, as you just heard. I'm an internationalist by education and as a professor in Göttingen on the one hand, and on the other hand, I'm a constitutional judge and justice, and I can only do that because the German constitution is against all odds, against all you might have heard otherwise, is friendly towards international law and European law, and even mandates the international and European integration of Germany. So these two identities match quite well with each other. And that is sometimes forgotten. In Germany, I always tend to say, in the German constitution, Europe comes directly after God and man, and I think that is quite prominent indeed. So it's not surprising that the general attitude of the German constitution towards international European law is described as open statehood, or even as friendliness towards international and European law. And that is a description also by the German Federal Constitutional Court. The provisions on supranational engagement are even going beyond those on regular treaty law. Thereby, the basic law seeks to overcome the supposed dichotomies between state sovereignty and international integration, and also the dichotomy between national democracy and international legality. With regard to European integration, the basic law even goes beyond the provision on classical international integration. On the other hand, as you know, democracy and parliamentary democracy plays an important role in German constitutional law. So in both instances, the German parliament, the Bundestag, increasingly claims the status as a co-equal branch, also with regard to foreign and in particular European relations. That's why the Second Senate of the Court, I belong to the first one, has allowed Parliament to modify the domestic effect of treaties, albeit within the constitutional limits, that is, being part of European integration and also accepting universal human rights. But disengagement, also disengagement by Parliament, comes at the price of incurring international responsibility. So indeed, Parliament has usually not paid the price except for double taxation agreements. In line with such a principle of mutual respect, both of parliamentary and democratic sovereignty on the one hand, and the respect for international law and international institutions, the Constitutional Court has developed 3 doctrinal devices and has borrowed from the theory of counter limits from the Italian Constitutional Court, even if Germany is neither a monist nor a dualist country, but somewhere in between, depending on whether it is customary law or treaty law. And also there are different interpretations. You know those elements from discussion, international discussion. It is about Solange, that is the principle of effectiveness. Human rights must be protected effectively internationally, otherwise we will take them home again. We have the constitutional control of ultra-virus acts when international institutions go beyond the mandate by treaty. And lastly, and most difficult, the identity control, which, however, has never been made sharp in a way that Germany could not implement an international decision. So let me now look at those elements in turn. The principle of open statehood is enshrined in the basic law as also a device for preventing Germany from ever again separating itself and its values from internationally recognized morality, law, and human rights. It is in a certain way and also an antithesis to the totalitarian abyss of the previous regime. Open statehood also, however, manifests practical considerations. International integration provided a natural escape for an occupied and morally as well as financially bankrupt states. You know that there are still the enemy clauses in the UN Charter, and that, I think, shows what Germany had to go up against. And this also allowed Germany to reintegrate internationally and reintegrate into Europe, and was, in the last resort, the best way to ensure reunification later on. Open statehood, of course, is an abstraction from the provisions of the Constitution. Nevertheless, the Constitutional Court has developed those 2 concepts of friendliness towards international law and towards European law from the provisions on integration in the German Grundgesetz. There is, in a way, the German Constitution has preordained integration through law, which, of course, Capelletti introduced into the European discussion in the 1980s. In Article 24, it provides for the direct effect of decisions by international institutions in the domestic legal order. In this way, a very monist kind of constitution, even accepting secondary international obligations as with direct effect. And on the other hand, it mandates also the membership in the United Nations and in a certain way also the acceptance of the decisions of the International Court of Justice, even if Germany declared became subject to the optional clause only in 2008. In a way, therefore, international integration is quite strong, and the question is, what are we doing with this democratic decision-making? Of course, Parliament has to agree to the ratification of the most important treaties, and also in particular of those treaties which need to be implemented in the domestic legal order. In a certain way, international engagement is thus not an antidote to domestic democracy. However, one may also claim that Parliament is, in a democracy, a changing body. So actually, after a new election, you may say that it must be able to also change the international engagements of Germany as far as the Constitution allows. With regard to international integration, there is the mandate, however, of Article 24, which also was used for the European integration until 1993. But there is a special provision for the European Union. Article 23 mandates German membership in the European Union. It was introduced after German unification and confirmed the choices by the framers of 1949. However, with a more skeptical mood developed in 40 years, it also introduced certain conditions. But those conditions are not really contradictory with the European engagement, because these conditions are those which we generally would accept and expect from a community or a union of values, of democratic values, which is not the Soviet Union, we have to tell our British friends occasionally these days, because it is about democracy, it's about subsidiarity of international engagement, which is, as you are well known, comes from a Catholic idea of subsidiarity of the state as well. It is about human rights and freedoms, and it is also requires a respect of German federalism by the European Union. And in fact, it is the Court of Justice of the European Union which has accepted these features, and Article 4 of the Treaty on European Union mandates them as well for the European Union. So actually the clash of identities that is talked up by many cannot be as strong as some will claim. Nevertheless, there is a certain necessity to ensure that international engagement doesn't go wild in a way. It is, in fact, a European judge, Georg Ress, who was judge of the European Court of Human Rights, who has created the term treaties on wheels. You know, the treaties are set on wheels, and you are at the station, and you can wave at the station, but then the treaty goes its own way. Is a treaty on wheels, and there are certain attempts to get those treaties, the wild treaties, in a certain control and under control, and certainly those elements, those counter limits, are an attempt to exactly do that, but remaining faithful to the original engagement as well. Now, this is a general picture, and now let me look at the details, in particular of those exceptions to international engagement. The first one is a formal one. As I said, recently, with regard to a double taxation agreement, the Second Senate decided that indeed Parliament can, by application of the principle of lex posterior, run away from an international engagement when it does so explicitly in the law. And Parliament has done so exactly once, and that is in the law on double taxation agreements. You don't find any other provision in that regard. The presumption that Parliament does not want to abolish international engagements is very strong. If there's not something explicit in a law, or maybe also the legislative materials, although this has never been practiced, then national laws have to be interpreted in line with international and European engagements. And of course, the domestic parliament cannot abrogate the international obligation of reparation. So it is a little bit the same situation when you are faced with two contradicting international engagements. For one of the two, you will have to engage in reparation instead. And that may be also the reason why Parliament is only rarely doing that, if it does so beyond the double taxation field, which is a very special one indeed. There may also be limits to such an activity by Parliament in the Constitution itself. Article 1, paragraph 2 explains that Germany accepts the universality of human rights, and so internationally recognized universal human rights cannot be abrogated in the domestic order, and in fact, the Second Senate has explicitly said so in its decision on these double taxation agreements. And of course, the European and international integration as such is also mandated by the Constitution and can be abrogated only by a change of Constitution for which there is no majority of 2/3 in both chambers of Parliament in sight. But this perceived necessity to get international engagements under a certain way of control has led to those three counter limits which the German Constitutional Court has spelled out quite in detail in the recent jurisprudence and since the Lisbon Treaty decision in 2009. But even with that, in that regard, the Second Senate has taken care that it does so as part of the European Association of Constitutional Courts, which is a translation of Europäischer Verfassungsgerichtsverbund, the very special German term of Verbund, which is somewhere between a federation and a confederation in the theoretical meanings of the term, not in the meaning of the Swiss Confederation, which of course is a federation, according to these notions. And therefore, it is on purpose that the German Constitutional Court uses terms that are also used by other constitutional courts, such as our Italian colleagues. We have already spoken about the Solange jurisprudence and about this condition of equivalent protection. Equivalent protection, the necessity that derogated powers need to be under the same kind of human rights protections as domestic powers, is almost now a general principle of law, whether or not in the sense of Article 38 of the ICJ statute is for others to determine and to research about. But we find it this topos, for instance, in the Bosphorus decision of the European Court of Human Rights. And in my reading of the CADI judgments of the diverse European courts, this is also for an international lawyer, most acceptable reading of the CADI jurisprudence, that it is one on equivalent protection, as long as the International Legal Order and the Security Council are hesitant to apply what they are mandated to do in Article 1 of the Charter of the United Nations, that is, to look for the respect of universal human rights. So indeed, I would say it does not play a large role with regard to the European Union at the moment because, of course, at least since the Charter of Fundamental Rights, the European Union is respectful of human rights and the court is implementing them. Nevertheless, this principle of equivalent protection may have a second life, if you like. The court has, in a case of the First Senate, pointed clearly out that all German courts are under an obligation to see to it that those rights in the sense of equivalent protection are also material. That is, they have to go to the European Court of Justice using the preliminary reference system if they are if they have gained the conviction that a European directive is violating the Charter of Fundamental Rights. This obligation has so far been spelled out for regular courts, and we are usually sending back cases to regular courts so that they can reference those cases to the European Court of Justice. This works reasonably well. Nevertheless, you will ask whether the Federal Constitutional Court has the same obligation, that is, to see to it that cases get to the European Court of Justice so that this gap in European law, that individuals cannot directly sue the European Union except for very special cases, which are handled also very restrictively by the European courts, that this gap is filled. I can't talk more about it, but you will probably hear about this more in the remainder of this year or at the beginning of next year from the Federal Constitutional Court. The second counter-limit is the ultra-virus principle. And in fact, the Second Senate in the 2009 judgment on the Lisbon Treaty regards this as a general principle even of international law. Of course, we know as internationalists that this is rather true for arbitration. Arbitral tribunals without competence to pronounce themselves, a state can say not to accept an arbitral award if it deems the court having stepped beyond the bounds of the arbitral award. So in fact, the ultra-virus limit is transferring this idea to judgments of international courts, and in particular to the European Court of Human Rights. However, in the case law of the Federal Constitutional Court, in particular the Honeywell judgment, the court emphasizes that the non-recognition of ultra-virus acts will be the rare exception. In fact, they may violate the act of transfer of competences. In fact, one has to say the transfer idea is not quite correct. It's more a confer of competences to an international organization. But of course, those confers are under certain conditions, namely that the new body is keeping to its mandate, is implementing its mandate and doesn't go beyond it. Nevertheless, ultra-vires review, and I quote, is contingent on the act of the authority of the European Union being manifestly in breach of competences and the important act leading to a structurally significant shift to the detriment of the member states in the structure of competences. That is, you need a manifest breach and you need a breach leading to a structurally significant shift. These are very harsh conditions for regarding an act as ultra-virus, and on top of this, you have first to refer the case to the European Court of Justice to enter into a dialogue whether there is another possibility to both implement international and domestic law on the question. So until now, we have never seen that an act has been declared ultra-virus and that this dialogue can work. We have seen with regard to the Italian Constitutional Court and the European Court of Justice in the Tarico affair, in the end, it was accepted that also European fundamental rights require the acceptance of statutes of limitation which had been recognized in the past. So actually, this is a good example how such confrontation between domestic and European courts can be avoided. That leads me to the third and last counter limit, which is probably the most difficult one: constitutional identity. And I must confess, don't tell my brethren, I have lots of problems with the word identity, because identity is something unquestionable. And we as lawyers have, of course, a task to question everything. If you say, this is my identity, how am I to tell you that this is not true? How could I? So we have to use this concept with care. On the other hand, as you are well aware, it is the Treaty on European Union itself which uses the concept in Article 4 of the Treaty on European Union, accepting national constitutional identity as such. Nevertheless, the Second Senate, in its reference in the OMT case, has pointed out that there is a divergence of views, apparent divergence of views between the European Court and the German courts regarding identity. The European Court of Justice has used national identity as a topos for balancing, and has balanced the unified application of European law on the one hand, and the domestic niceties, if you like, of domestic identity on the other. And in fact, they have done this with a domestic nicety. I hope this doesn't offend my Austrian colleagues, but it is about the right or not of nobility to carry their names, which was the topic on which the court has dealt with this topic. That, of course, may go at the core of identity of some people, but it's certainly not the core of what characterizes our respective constitutions. On the other hand, the Federal Constitutional Court is, in fact, identifying German constitutional identity with very clear wording of the Federal Constitution itself. I've cited already Article 23 on the integration into the European Union, and this article refers to another article, Article 79, paragraph 3 of the Grundgesetz, which is the famous eternity clause, which says certain features of this constitution cannot be abrogated. You would need a new constitution, which would be illegal from the standpoint of the present constitution. And these are even more narrow than those conditions for European integration in Article 23, because it says it's only human dignity and universal human rights and their authority over all power exercised by the state. It is democracy, it is a social state, and it is only the main principles of these and not every emanation which you find in the jurisprudence. And of course, it is a Rechtsstaat rule of law principle as well. So these are very basic principles of a liberal democratic state. And I emphasize this time the word liberal because you know that others think that there is something like an illiberal democracy, which in Germany would be clearly contrary to constitutional identity. But is really the European Union endangering that understanding of constitutional identity? I hope not. It is, if you like, a last resort, a safety valve. It is not a general challenge to the European Union, which would mandate a second, let's say, a second judgment after every European Court of Justice judgment, which would declare whether or not it conforms to the German legal order. And that's why, in fact, if this is treated with great care, I would also suggest that it does not end up in a permanent reserve towards European integration. A decent interpretation with mutual respect can solve that such a conflict as well. So the Constitutional Court has never used this break so far. It has, however, used the identity control for pointing out that, first of all, it accepts those cases beyond what the Solange jurisprudence would suggest, that you have to argue that the whole system of human rights protection breaks down. No, it will accept also individual cases claiming that human dignity was violated. And in that case on identity control, it came to the conclusion that the domestic court, not the European Court of Justice, had erred and had not challenged the idea that the receiving state, and it was an extradition matter, actually it was Italy is concerned, was respecting those minimum requirements, in particular the right to be heard. Indeed, it is a lower court which is under the mandate and has referred that case to the European Court of Justice. But the European Court of Justice has reacted earlier than expected. In the Aranyoso-Calderaro case, it has indeed limited the principle of mutual trust in the European legal order to instances where there are no serious challenges to the practice of the receiving state of an extradition. So actually, you can say that this way of identity control is also not limiting the jurisprudence of the European Court of Justice. If anything, it is limiting mutual trust, and unfortunately, we have seen instances recently in which this kind of more cautious way in exercising mutual trust in Europe has been justified. And I think we have to work all by realizing not only constitutional identity, but also European identity to change these instances of challenges to the basic European constitutional identity in Europe itself. You know what I mean, I don't have to spell this out in detail. So I come to my conclusion. I would suggest that maybe we shouldn't talk so much about monism and dualism anymore. We should talk about a pluralist situation in the Europe of the 21st century that fits well with postmodernism as a concept. And the interrelationships are very complicated and are very detailed and are very discrete. They are different for the relationship between our constitutional orders and the European Convention on Human Rights, for instance, and the Charter of the United Nations, and the Treaty on European Union and the European treaties. So we have to look at a lot of contingencies there, and we have to deal with this pluralism. And at the same time, as international, European, and domestic constitutional lawyers, we have to explain to the general public what we are doing. And that's also part of our present predicament, that you have the feeling that a lot of people say, oh, those experts are doing things very widely away from me, and I want to get back control. And we have to show to them that this control is exercised in their favor and not against their interests. So this is a huge, tall order, which not only lawyers have to do, but all our political officials. But I think that in such a system in a pluralist system of multiple legal orders, mutual respect and mutual accommodation is the right way to proceed. And I hope and I'm sure that we all will strive to get to that result. Thank you very much.
Thank you. Thank you very much, Professor Paulus, for introducing us into the specific topic concerning the relationship between German law and EU law, which has some peculiarities that may be found in other countries now, and in particular in Italy, I would say, and the solutions that have been brought by the Bundesverfassungsgericht. Now we stop here for this session. There will be no discussion. I thank you, my rapporteur, for being very compliant with the time limits that were given to them. And I leave the floor to Professor Poccar and to SIDI for the consegna dei premi SIDI for 2018. Thank you.